You can be seated. The matter before the court is State of Maine versus Ronald Harding. This is Penobscot 23-376. Counsel are present. I'm assuming ready to proceed. We are being streamed live on the web and by video as well. If counsel would identify yourselves by saying your name for the record together with the party you represent, starting with the appellant.
Good morning. Rory McNamara for the appellant, Ronald Harding.
Leanne, Robbin for the State of Maine.
Thank you. And Mr. McNamara, if you're ready to proceed, we'd be happy to hear your argument.
May it please the court, Counselor. The expert called by this...
Green light.
Yes,
you
please.
asked for it.
Please, bring it on.
I'd like to explore your prosecutorial error
Great.
argument a little, because you are allowed to cross an expert on how much are you getting paid.
Right.
There's nothing wrong with that. So that means at the closing, you can say something like, over there are the guys that are getting paid $1 gazillion. Over there are the hardworking ambulance people or whatever. So what, I know your answer is going to be this case, but where do you cross the line and why?
I actually don't think that, so stepping back, bigger picture, I don't think that that's a great practice, in particular for criminal cases, because all criminal defendants...
Okay, but not being a great practice does not necessarily mean reversible error.
Well, let me talk about Steen. Steen is a case where actually that happened. That happened. They said, I think the opinion is more to do with the $2,500 or whatever it was. It was a big amount back in 1980, whatever. And that was one of the reasons why the law court said reversible error in that case. So I do think there's a basis in Maine law to say it is not a great idea. But also there's a decision cited in the blue brief out of New Jersey that says this is really a bad idea in criminal cases in particular, because criminal experts are always going to be the retained folks. And the experts, they're not even retained, they're on salary for the state, or are not, it's not going to be the same comparable type of arrangement. So that is a bigger picture thing.
Well, your citation of Steen is somewhat diluted by Justice Clifford's article that came afterwards that tended to suggest that there were other things in Steen that made it a problem that aren't present in this case, correct?
Well, there were many mentions in Steen of, are you lying?
Yes.
You mean the witness is lying? And here, I think we don't have that aspect. Certainly the quantity of amounts of comments, does that mean this witness is lying? But here we have a very central witness. This battle was pitched over expert testimony and which expert was believed. And notwithstanding the state's brief, I think that there could have been reasonable doubts. Remember, that's all we need here is reasonable doubts in Dr. Taylor's testimony. But when that is attacked in a way by suggesting that defense counsel is just going out and hiring them to say the opposite of whatever the state says, that is implying that what you're looking for is a liar.
Well, it's pretty subtle implication. I mean, when you're just saying this person's getting X dollars an hour, I don't think anybody says that's bad.
Right. But that's not what happened here. Here, the prosecutor said, you know, it's not the job of our experts to go out and cherry pick, to go out and search the internet for mitigating information for things that could plausibly go towards a defense. And the statement was, the defense witness...
Well, they didn't say to find information for the defense. It said it wasn't the job of these medical professionals to come into court and give opinions supporting one side or the other, to search the internet and cherry pick for information to try to come up with, and that's when the objection happened.
Right. And
I mean, when I first read that, I didn't even think of it was referring to the defense Apparently others did, but I didn't.
Right. Defense counsel certainly thought it, and preceding that was the comment that that Dr. Taylor had been hired by the defense to say this was not inflicted trauma.
But aren't we reviewing this at this point really for obvious error? I mean, there was a question about the curative instruction,
Correct.
and then is it actually
Correct.
waived?
I concede.
Because, well,
sorry.
is it actually fully waived once the request for curative instruction is intentionally withdrawn? Is that utterly waived?
No, it's not waived because there was no intentional waiver of the notion that this is coming on appeal. I'm going to give up on that. I'm not even going there. There was a strategic decision to not invite a comment, a curative instruction I think counsel rightly thought wouldn't have been
Or any other
good.
remedy, such as mistrial or anything else.
He didn't explicitly seek a mistrial, which I think he should have. However, it's not waiver because he's not saying I don't want anything. He's saying I don't want that curative instruction over there. If I were here arguing about that,
He didn't propose an alternative. What do you make of our language in State versus Scott when we said the court will not undertake an obvious error review when a litigant affirmatively approves or consents to a court action?
So here he was not consenting to the argument. Certainly, there's no question.
No,
He
but
stood
it was
up and
consenting to the court action of not giving a curative instruction.
And I think that's the prerogative of defense counsel to say a jury instruction that closing arguments are not evidence, if you will. Well, that will already be mentioned. A second one will only draw more attention to it. But he didn't go the extra mile. He didn't say, I am asking for a mistrial here. And I think there's a clear distinction between the two. Taking a step back, can you imagine if defense counsel said, to Your Honor's question, the prosecution hired the lead detective to cherry pick and make it seem like the defendant is guilty? Or if defense counsel stood up in closing and said, the medical examiner is paid to testify and
Well,
get
to respond to
convictions.
your argument that this was a critical witness, this is the expert who said it was COVID, and you haven't really forwarded that as a viable defense to us. Instead, you've been focusing on the state's expert and the question of whether the trauma was inflicted earlier. I mean, does this COVID argument really have sufficient legs that it's obvious error here?
The difference, of course, between the criminal cases and the civil cases, I'm going back to where I started this conversation, is all we're trying to do is establish a reasonable doubt here. And I do think that there could have been a reasonable doubt, but for this very realistic and easy, it's almost like a form of common sense, right? And that's what's dangerous about this, for the prosecutor to put out there that you shouldn't trust this person over there. They were paid a lot of money or they were hired by the defense
Well, that's
just
not
to
what
come
they
in and say
said.
this
I mean,
thing.
I know that that's what you're inferring, but that's not what they said.
Can I take you back? You just made a comment just a moment ago, following up on the Chief's question, that if the defense said, well, the prosecution had just done this, this, and this, and I think you were about to say that's not good, that should not happen. Fair statement so far?
Yes.
Are you, as Justice Connors pointed out, there is a body of case law that says talking about witnesses' motivation is appropriate. Would you favor a rule that says that counsel in closing cannot comment on the motivation or the source of expert testimony?
No, I don't think that that's appropriate. Motivation is important. However, it is the implication, and I push back on the Chief Justice's, I think we're having a difference of understanding as to what was said. To me, the statement that somebody was hired to come in and say something rather than evaluate all the evidence and then tell the truth, that's the problem.
Is this
how
statement
about the
faulting
evidence?
counsel or the witness?
I'm sorry.
Is the prosecutor's statement attacking the prosecution for looking for somebody or attacking the witness for being found?
I think it's attacking defense counsel and the witness.
Attacking prosecution counsel.
No, that statement that this witness was hired to say that this wasn't inflicted trauma, those are the words, that is attacking two things to me. It's attacking Dr. Taylor, the
Yes.
witness, and defense counsel or
yes.
defendant for going out and hiring somebody, almost like suborning perjury, which is the implication to me that we're not looking for somebody to say the truth.
So wouldn't it be great to have a curative instruction for the judge to say to the jury, please disregard the prosecutor's statements regarding the source of the witnesses. All witnesses are entitled to be considered independently by you.
I think that that statement doesn't resolve anything. And this is what I mean. It's a very deleterious thing to say because natural common sense is inclined to do that. And the instructions that the jury gives from Alexander that says you can evaluate the motivations for a witness's testimony, X, Y, Z, and it might be this. And naturally, one of the things we want to do is, well, what are the motivations? What are
exactly
out there? So I think that jury instruction wouldn't have resolved anything.
But would it have helped, maybe?
No, I think
not helped it. So it's a strategic decision saying, that's not going to do anything for me. Don't want it. Don't talk about it.
Well, I'm not sure if it would have helped or not, but I understand defense counsel saying that I'm not asking for it in these circumstances because I think it's going to draw more attention to it, and just because that comment is already covered, right? The closing arguments are not in evidence. That's part of this argument.
I interpret your argument to be let me just back up and say evidence of bias is always admissible.
Correct, yes.
And bringing out the fact of payment is
admissible.
Appropriate.
Yes.
Your argument is that it shouldn't have gone to the next step, that the payment has caused the witness to testify in a particular manner, to cherry pick, et cetera.
Yeah, and just to tweak that a little bit, it's not necessarily the payment because the payment wasn't specified. We're right. We're not dealing with that here. But it's the fact that somebody was hired to say X, to say it's not inflicted trauma. That's not the way a defense relationship with an expert goes. A defense goes out there and says, here are the facts, can you evaluate these? And of course, here's the part that should stay away from the jury. You're not going to hear about defense witness experts that can't help you, of course, at trial, but I think that part needs to be kept from the jury because that's just the nature of experts on all of our cases.
Okay, you've got less than a minute. Let's go to your other argument. And I'll ask a quick question, which is, wasn't this a battle of the experts and you lost?
No.
Not you, but the lawyer.
Sure. I appreciate that. The state had a burden, and in all abusive head trauma, in all shaken baby cases, the state has a burden. In order for this very discrete and intricate mechanism and the timing to work, to prove that the victim, the decedent, was healthy. And the witness called by the state to say, well, here's the state of Jaden's brain tissue, said no.
But there were multiple other people who said, this is what we believe happened, and this is the only explanation, that this baby could not have taken a bottle, could not have been alert, et cetera, once this devastating injury occurred. Why isn't that then a jury question with the jury free to ignore or give little weight to, was it Dr. Bundruck?
Bundock, yes.
Yeah.
If I may answer the question. Thank you. She was the last witness to touch the body, to examine the body, to know all that information that those other witnesses did not have. And she was the one, in fact, that Dr. Funte, the medical examiner, said, we need her to go ahead and do that.
Okay.
Thank you.
Chief Justice Stanfield, Associate Justices, may it please the court. If you can't call out a defense expert, how is there going to be justice in a criminal trial? There are a number of experts now throughout the country that are marketing themselves as experts that the defense can use in shaken baby cases. And Dr. Turner is one of those experts who is proffering infection as viral infection as an alternate cause of this closed head traumatic injury. In this case, the treating physicians and Maine's deputy chief medical examiner all agreed Jaden Harding suffered a traumatic brain injury caused by shaken impact syndrome. an acceleration-deceleration injury accompanied by blunt force to the back of his head. As a result, the bridging veins connecting Jaden's brain to the dura were severed, causing an acute hemorrhage that cut off the blood and oxygen to his brain, in turn causing Jaden to become immediately unresponsive. There's no dispute that he lost consciousness while in the exclusive care of his father, Ronald Harding. The defense expert, however, had a different theory. She said COVID killed baby Jaden. There was no evidence of COVID symptoms, no evidence of a viral infection that would cause the significant and diffuse brain injury that Jaden presented with at the hospital. And there was no error in the state pointing to evidence that showed that the COVID theory was entirely without merit, and to point out the lack of bias on the part of the treating physicians in coming to their conclusion that Jaden's brain injury was inflicted, and that it was inflicted immediately before he lost consciousness. The treating physicians have no dog in this fight. The fact that their lack of bias reflected badly on an expert that came up with the highly questionable theory that COVID killed baby Jaden was not a result of any unfair invective or characterization by the prosecution or any injection of a personal opinion by the prosecutor. It was a result of the detailed analysis of the evidence presented at trial that led jurors to the conclusion that Ronald Harding inflicted the traumatic brain injury on his son. I'd be happy to take questions.
Well, let me start with the same question I asked Mr. McNamara. Where is the line between, in the closing of a prosecutor to say they got paid, they were hired to make the decision, and the implication that therefore cherry picking, is that a good word to use?
Right.
Where's the line?
Well, in this case, I think cherry picking was a very good word to use because the cross-examination of Dr. Turner showed that she was picking and choosing information from many medical journal articles. Her experience with COVID was primarily from those articles. She had not reviewed a single case of a child going from healthy to brain dead in seconds due to COVID. She had none of the 2 to 3 autopsies that she'd done on adults who had died with COVID had involved a subdural hemorrhage, such as the one that Jaden suffered.
Do you think this was a waived argument or obvious error, the prosecutorial error?
I don't believe it's error, Your Honor.
Okay.
If it were error, if it were error, I would say this. I would venture to say that it's obvious error.
So you would not say it was waived?
It was, well, I mean, it was interesting. Defense counsel, when he objected, he said, there's a law court decision on this, and it's written, I forget, somewhere else, and he never proffered that legal authority to support his objection to the argument that I was making. And so then when he withdrew his request for curative instruction, I assumed, perhaps wrongly, that it was because he couldn't find the case that he thought he had read that said that what the prosecution had said was an error.
There was an argument, though, explicitly that he hired an expert to say this was not inflicted trauma, which is, I think that's at page 88 of the transcript. So isn't that different than saying this is a hired expert? I mean, you are specifically saying he was hired for this purpose, to whether or not it's true,
right,
to say it wasn't inflicted trauma. Now, that there wasn't actually an objection at all to that.
Right.
But isn't that problematic?
I think context is everything, Your Honor. And in this case, the context of that comment was the number of statements that Mr. Harding himself had made. First saying that the baby just suddenly lost consciousness when he did nothing to the baby, and then blaming the mother of the baby.
Well, I understand why you think that the theory is absurd.
Yeah.
But, and I get that you feel that way strongly.
Yeah.
But the statement is that the defense hired an expert to say this was not inflicted trauma, not that the opinion wasn't credible.
Right. I then went on to talk about how the opinion was not credible. I backed that up with the evidence in the record. And I guess in hindsight, to be absolutely perfect on the wordsmithing, probably would have been better to say, hired an expert who said that the baby died of COVID. Does one word in a sentence in closing argument make the kind of error that
Well, that's a different question, whether it's obvious error at that point. But I guess, isn't it concerning that it's like you hire him to say something as opposed to hired them and they are now saying this?
The better course would have been to say, hired an expert who said this, and that was certainly the intention. But certainly, you know, she was hired to provide an alternate explanation. Unlike, I think there's a slam at the deputy medical examiner in the reply brief that talks about salaries, and the deputy chief medical examiner doesn't get paid to come to testify at court.
Well, I guess then are you really saying that any time in a criminal case when the defendant presents an expert, they're always paid to present information that is helpful to the defendant, because as Mr. McNamara said, if they you know, talk to 10 different experts, you're not going to hear about the 9 that weren't helpful. Of course they're only going to put on somebody that's helpful.
Right. And we did, in fact, have a retained expert. Dr. Bunduck from Vermont was retained by...
Wasn't helpful for you, was it?
In some ways. I mean, in some ways she was, in some ways she wasn't. She excluded the alternate causation of infection. And I believe that her statements about the timing have been somewhat overstated.
Yeah, going back to the Chief's previous question about the language there, and you said substituting another word would have made that a little bit better coming through the door, but the words that were used here were almost a sideways shot at defense counsel. It makes it sound like defense counsel did this, went out and found somebody to say this. And of course, in the closing argument, that's when counsel want to cash in the credibility they've built up with the course of the trial. And if that was taken as a shot at the credibility of defense counsel, that would not be okay. Is that correct?
It was not intended as a shot at...
No, I don't think it was.
Yeah,
I don't think for a moment think it was intended, but the way it came out, almost
regardless of intention, when a closing argument links the substance of an expert's testimony to their compensation, isn't that necessarily expressing an opinion on the credibility to be given to the testimony?
It does show. I mean, doesn't that also go to bias? And I think even Justice Clifford acknowledged that there are ways to say that there, you know, who retains an expert, who it goes to their bias, goes to whether they wanted to. It seems like some of these experts are turning themselves into pretzels in order to give the opinion that will support the defense, and certainly in this case, this expert did. And so I think it's entirely appropriate to say, look, this is the expert that was chosen by the defense, and is here for the defense.
I understand the defense's the appellant's argument to be, it's okay to bring out the fact of payment. It's okay to say that the witness is cherry picking. What's not okay is to say, because the witness is being paid, the witness is cherry picking.
I don't believe that was said during that argument. I don't believe that was said at all. It certainly wasn't. It was a criticism of the expert's methodology and how she came to her expert opinion. And again, the treating physicians were not people that we retained. They were, we came in and took them as we found them, and they expressed their opinions. And 201, I mean, no one could understand how an expert could come to a conclusion that COVID killed baby Jaden. And how do you express that? How do you express that as a prosecutor with all the limitations that we have? How do you express that this opinion is out of bounds, wacky, crazy, hogwash? How do you do that? And in this case, it was to criticize her methodology of picking and choosing what she liked from various medical journal articles to cobble together her theory of COVID that didn't make any sense once it was exposed to cross-examination. It doesn't. I mean, it was a theory that somewhat was backed away from by defense counsel, even at the trial level, and it certainly hasn't been.
Well, the focus on appeal seems more to be attacking your expert and setting aside the COVID theory,
right? And
saying it could have happened earlier,
right?
And I think the argument is that given the beyond reasonable doubt that the attack on that expert is sufficient to warrant a finding of insufficient evidence. Can you respond to that?
It's really hard. I mean, I think it's turning the standard of appeal on its head, because we're not, this court's job is not to credit a single portion of testimony and try to interpret it in the light most favorable to the defense, and then analyze whether it could have somehow overridden all the other evidence in the case that supported the elements of manslaughter beyond a reasonable doubt. Instead, this court's job is to look at the evidence in the light most favorable to the state to determine whether the jury could have rationally found all the elements of manslaughter.
But I think Mr. McNamara's argument really is not that she was necessarily a more credible expert than the other experts, but that in this case, as in most cases of inflicted trauma on a baby, the prosecution's case is really circumstantial. You're saying essentially baby was solely in his custody, therefore it must have been him that did it. And that when you have an expert that says, well, it didn't necessarily happen in that time frame at all, that is the problem here. As I understood his argument, that's the issue. It's not because one expert is more credible than the other, but it has to do with the specifics of this kind of case where you're really trying to make your case over the fact that no one else could have done it. It's not that it was, whether it's inflicted or not, it's that no one else could have done it. And that's the significance of Dr. Bunrock's testimony.
Well, Your Honor, that the jury was instructed as to how they can weigh or evaluate witness testimony, including expert testimony. And they don't have to take the whole enchilada. They don't have to. They can give some portions of it weight and disregard others. And in addition, Dr. Bundock testified that her observation of the hemosiderin deposits did not exclude the state's theory that the blunt force injury occurred at 7 o'clock on the date that that baby Jaden presented to the emergency room. That you can't just look under a microscope and determine the timing of the injury. That the studies on hemosiderin are based upon adults and not on children. And
it could be from birth, I think.
It could be, yeah, that's correct. It could be from birth. There are other causes that it could come from. But what Dr. Bundock did not see was the bright red acute blood that Dr. Fonte saw when he opened up the brain, because he has to then package the brain and send it to Vermont. And that's where Dr. Bundock sees it. So Dr. Bundock does not have the benefit of the fresh red blood.
But she was aware. I mean, we had a subgaleal, subdural, and a subarachnoid hemorrhage in this case.
That's right.
And she knew that.
She knew that. But again, she was not saying that this means that the fatal injury didn't occur at 7 o'clock that night. She did not say that. It's the defense that has interpreted it in that manner. And based upon the other evidence in this case, there was more than sufficient evidence to prove manslaughter beyond a reasonable doubt.
Thank you. Mr. McNamara, you wish to be heard in a rebuttal.
Thank you. It matters how that fatal injury was inflicted. It has to have been grossly deviantly. The theory, there are at least 14 mentions in the transcript, and I urge the court, if it hasn't already, to read the 100 or so pages of transcripts of Dr. Bundock. She insisted that 2 to 3 days prior to death, there was blood in Jaden's brain.
But that's not inconsistent with there also having been the traumatic injury at approximately 7 p.m.
Correct.
That was in fact the cause of death.
Correct, but again, how is that traumatic injury inflicted? Common sense says that if we have an injured brain, an ongoing brain hemorrhage in a child, in a 6-week-old child, that perhaps normal care, that an accident, that a 4-year-old could inflict these sorts of injuries.
I'm not sure that's such common sense.
Well,
That's also not in the record. I mean, and Dr. Paca,
that's correct.
He called this a terrible trauma. He compared this to an adult in a snowmobile accident. I don't think a 4-year-old, well, perhaps a 4-year-old could, but there's no
Perhaps a 4-year-old could to a boy who has got an ongoing brain hemorrhage. That's the important point that makes this case different than all the other abusive head trauma cases, that all the other shaken baby cases that come before it. We don't have a healthy child. We have a child with a very severe, moderate hemosiderin deposits. And it was not just from birth, according to Dr. Bundock. Dr. Bundock said it was a little bit too much. It was more than I would expect. That's the second volume, page 63. Those deposits were not from birth. They were something other than that. And I think this court has, I look to the Robbins decision, Justice Mead's decision in 2019, has, when fairness and justice requires it, it has done things to make sure that people are not convicted of crimes. And I think we look at Rule 1 of appellate procedure and Rule 2 of the criminal procedure, where fairness and justice dictate. Here we have the state's own witness, the only witness who examined the brain tissue of Jaden, saying, no, there was ongoing bleeding in this boy's brain. And I think that that's a really serious and fundamental cause for concern for this court on this evidence, on this record. Thank you, Your Honors.
Thank you. As always, counsel, thank you for your argument here this morning. We will, however, be taking this matter under advisement. We will issue a written decision in due course. With that, we're in recess for the day.
All persons having anything further to do before the honorable justices of the Supreme Judicial Court, sitting as the law court, may hence depart and give their attendance here at 9:50 tomorrow morning, as this court now stands adjourned. God save the state of Maine and this honorable court.